Now let's learn Chapter 4 of the Companies Act 2013, Share Capital and Debentures. According to Section 43, Kinds of Share Capital. The share capital of a company limited by shares shall be of two kinds, namely equity share capital with voting rights or equity share capital with differential rights as to dividend, voting or otherwise in accordance with such rules as may be prescribed. The next type is preference share capital. Provided that nothing contained in this Act shall affect the rights of the preference shares who are entitled to participate in the proceeds of winding up before the commencement of this Act. For the purpose of this section, equity share capital with reference to any company limited by shares shall mean all share capital which is not preference share capital. Preference share capital with reference to any company limited by shares means that part of the issued share capital of the company which carries or would carry a preferential right with respect to payment of dividend, either as a fixed amount or an amount called as a fixed rate, which may either be free of or subject to income tax, and repayment in the case of winding up or repayment of capital of the amount of the share capital paid up or deemed to have been paid up, whether or not there is a preferential right to the payment of any fixed premium or premium on any fixed scale specified in the memorandum or articles of the company. Company shall be deemed to be preference capital, notwithstanding that it is entitled to either or both of the following rights, namely, that in respect of dividend, in addition to the preferential rights to the amount specified in subclause A of clause 2, it has a right to participate whether fully or to a limited extent with capital not entitled to the preferential right aforesaid. That in respect of capital, in addition to the preferential right to the repayment on a winding up of the amount specified in subclause B of clause 2, it has a right to participate whether fully or to a limited extent with capital not entitled to that preferential right in any surplus which may remain after the entire capital has been repaid. Nature of shares or debentures. The shares or debentures or other interest of any member in a company shall be movable, property transferable in the manner provided by the articles of the company. Numbering of shares. Every share in a company having a share capital shall be distinguished with a distinctive number, provided that nothing in this section shall apply to a share held by a person whose name is entered as holder of beneficial interest in such share in the records of a depository. Certificate of shares. A share certificate issued under the common seal, if any, of the company, or signed by two directors or by a director and the company secretary, wherever the company has appointed a company secretary, specifying the shares held by any person, shall be prima facie evidence of the title of the person to such shares. So, a share certificate should bear a common seal or it should bear the signature of 2 directors or a director and a company secretary. A duplicate share certificate may be issued if such certificate is proved to have been lost or destroyed, or has been defaced, mutilated, or torn, and is surrendered to the company. Notwithstanding anything contained in the articles of a company, the manner of issue of a certificate of shares or the duplicate thereof, the form of such certificate, the particulars to be entered in the register of members, and other matters shall be such as may be prescribed. Where a share is held in depository form, the record of the depository is the prima facie evidence of the interest of the beneficial owner. If a company with intent to defraud issues a duplicate certificate of shares, the company shall be punishable with fine, which shall not be less than 5 times the face value of the shares involved in the issue of duplicate shares, but which may extend to 10 times the face value of such shares, or rupees 10 crores, whichever is higher, and every officer of the company who is in default shall be liable under section 447. According to section 47, voting rights, subject to the provisions of section 43 and subsection 2 of section 50, every member of a company limited by shares and holding equity share capital therein shall have a right to vote on every resolution placed before the company. His voting right on a poll shall be in proportion to his share in the paid up equity share capital. Every member of a company limited by shares and holding any preference share capital therein shall, in respect of such capital, have a right to vote only on resolutions placed before the company which directly affect the rights attached to his preference shares, and any resolution for the winding up of the company or for the repayment or reduction of its equity or preference share capital, and his voting right on a poll shall be in proportion to his share in the paid up preference share capital of the company, provided that the proportion of the voting rights of equity shareholders to the voting rights of the preference shareholders shall be in the same proportion as the paid up capital. In respect of the equity shares bears to the paid up capital in respect of the preference shares. Provided further that where the dividend in respect of a class of preference shares has not been paid for a period of 2 years or more, such class of preference shares shall be given a right to vote on all the resolutions placed before the company. Section 48 states variations of shareholders' rights. When a share capital of the company is divided into different classes of shares, the rights attached to the shares of any class may be varied with the consent in writing of the holders of not less than 3/4 of the issued shares of that class, or by means of a special resolution passed at a separate meeting of the holders of the issued shares of that class. If provision in respect to such variation is contained in the memorandum or articles of the company, or in the absence of any such provision in the memorandum or articles, if such variation is not prohibited by the terms of issue of the shares of that class, provided that if variation by one class of shareholders affects the rights of any other class of shareholders, the consent of 3/4 of such other class of shareholders shall be obtained, and the provisions of this section shall apply to such variation. Where the holders of not less than 10% of the issued shares of a class did not consent to such variation or vote in favor of the special resolution for the variation, they may apply to the tribunal to have the variation cancelled, and where any such application is made, the variation shall have effect unless and until it is confirmed by the tribunal, provided that an application under this section shall be made within 21 days after the date on which the consent was given or the resolution was passed, as the case may be, and may be made on behalf of the shareholders entitled to make the application by such one or more of their number as they may appoint in writing for the purpose. The decision of the tribunal on any application under subsection 2 shall be binding on the shareholders. The company shall, within 30 days of the day of the order of the tribunal, file a copy thereof with the registrar. Where any default is made in complying with the provisions of this section, the company shall be punishable with fine, which shall not be less than 25,000 rupees, but which may extend to 5 lakh rupees, and every officer in default shall be punishable with an imprisonment for a term which may extend to 6 months, or with a fine which shall not be less than 25,000 rupees and which may extend to 5 lakh rupees, or with both. It may be a fine, or it may be an imprisonment, or it may be both. According to section 49, calls on shares of some class to be made on uniform basis. Where any calls for further share capital are made on the shares of a class, such calls shall be made on a uniform basis on all shares falling under that class. Explanation. For the purpose of this section, shares of the same nominal value on which different amounts have been paid up shall not be deemed to fall under the same class. According to section 50, company to accept unpaid share capital although not called up. A company may, if so authorized by its articles, accept from any member the whole or a part of the amount remaining unpaid or any shares held by them, even if no part of that amount has been called up. A member of the company limited by shares shall not be entitled to any voting rights in respect of the amount paid by him under subsection until that amount has been called up. Payment of dividend in proportion to amount paid up. According to section 51, a company may, if so authorized by its articles, pay dividend in proportion to the amount paid up on each share. Application of premiums received on issue of shares. Where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount of the premium received on those shares shall be transferred to a securities premium account, and the provisions of this act relating to reduction of share capital of a company shall, except as provided in this section, apply as if the securities premium account were the paid up share capital of the company. Notwithstanding anything contained in subsection, the securities premium account may be applied by the company towards the issue of unissued shares of the company to the members of the company as fully paid bonus shares. In writing off the preliminary expenses of the company, in writing off the expenses, the commission paid, discount allowed, any issue of shares or debentures of the company. In providing for the premium payable on the redemption of any redeemable preference shares or any debentures of the company for the purchase of its own shares or other securities under section 68. So these are the purposes for which securities premium account is used. The securities premium account may, notwithstanding anything contained in subsections, be applied by any class of companies as may be prescribed, whose financial statement comply with the accounting standards prescribed for such class of companies under section 133. In paying up unissued equity shares of the company to be issued to members of the company as fully paid bonus shares, or in writing off the expenses of or the commission paid or discount allowed on any issue of equity shares of the company, or for the purpose of its own shares or other securities under section 68. A prohibition on issue of shares at discount. According to section 58, there are certain provisions which prohibit issue of shares at a discount. Except as provided in section 54, a company shall not issue shares at a discount. Any share issued by a company at a discounted price shall be void. Where a company contravenes the provisions of this section, company shall be punishable with a fine, which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees, and every officer who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with fine shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees, or with both. So the fine amount may be from 1 lakh to 5 lakhs, and imprisonment which may extend up to 6 months, or both. So we should remember the punishment mechanism, the penalties which are provided under the Companies Act 2013. According to section 54, issue of sweat equity shares. Notwithstanding anything contained in section 53, a company may issue sweat equity shares of a class of shares already issued if the following conditions are fulfilled. The issue is authorized by a special resolution passed by the company in an extraordinary general meeting. The resolution specifies the number of shares, the current market price, consideration, if any, and the class or classes of directors or employees to whom such equity shares are issued or to be issued. Not less than 1 year has at the date of such issue elapsed since the date on which the company had commenced business, and where the equity shares of the company are listed on a recognized stock exchange. The sweat equity shares are issued in accordance with the regulations made by the Securities and Exchange Board in this behalf, and if they are not so listed, the sweat equity shares are issued in accordance with such rules as may be prescribed. The rights, limitations, restrictions, and provisions, or for the time being applicable to equity shares, shall be applicable to the sweat equity shares issued under this section, and the holders of such shares shall rank pari passu with other equity shareholders. Section 55 states, issue and redemption of preference shares. No company limited by shares shall, after the commencement of this Act, issue any preference shares which are irredeemable. A company limited by shares may, if so authorized by its articles, issue preference shares which are liable to be redeemed within a period not exceeding 20 years from the date of their issue, subject to such conditions as may be prescribed, provided that a company may issue preference shares for a period not exceeding 20 years for infrastructure projects, subject to the redemption of such percentage of shares as may be prescribed on an annual basis at the option of such preferential shares. Provided further that no such share shall be redeemed except out of the profits of the company which would otherwise be available for dividend, or out of the proceeds of a fresh issue of shares made for the purpose of such redemption. No such share shall be redeemed unless they are fully paid. The share should be fully paid to qualify for it to be redeemed. Where such shares are proposed to be redeemed out of the profits of the company, they shall, out of such profits, be transferred a sum equal to the nominal amount of the shares to be redeemed to a reserve called Capital Redemption Reserve Account, and the provisions of this act relating to reduction of share capital of a company shall, except as provided in this section, apply as if the Capital Redemption Reserve Account were paid up share capital of the company, and in case of such class of companies as may be prescribed and whose financial statement comply with the accounting standards prescribed for such class of companies under section 133, the premium, if any, payable on redemption shall be provided out of the profits of the company before the shares are redeemed. Provided also that premium, if any, payable on redemption of any preference shares issued on or before the commencement of this act by any such company shall be provided for out of the profits of the company or out of the company's securities premium account before such shares are redeemed. In case not falling under subclause above, the premium, if any, payable on redemption shall be provided for out of the profits of the company or out of the company's securities premium account before such shares are redeemed. Where a company is not in a position to redeem any preference shares or to pay dividend, if any, on such shares in accordance with the terms of issue, such shares hereinafter referred to as unredeemed preference shares, it may, with the consent of the holders of the 3/4 in value of such preference shares and with the approval of the tribunal on a petition made by it in this behalf, issue further redeemable preference shares equal to the amount due, including the dividend thereon in respect of the unredeemed preference shares, and on the issue of such further redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed, provided that the tribunal shall, while giving approval under this subsection, order the redemption forthwith or preference shares held by such person who have not consented to the issue of further redeemable preference shares. Explanation. For the removal of doubt, it is hereby declared that the issue of further redeemable preference shares or the redemption of preference shares under this section shall not be deemed to be an increase or, as the case may be, a reduction in the share capital of the company. The Capital Redemption Reserve Account, notwithstanding anything in this section, be applied by the company in paying up unissued shares of the company to be issued to members of the company as fully paid bonus shares. For the purpose of subsection 2, the term infrastructure projects means infrastructure projects specified in Schedule 6 of the Companies Act, given as an annexure at the end of the Act. Transfer and transmission of securities. A company shall not register a transfer of securities of the company or the interest of a member in a company in the case of a company having no share capital other than transfer between persons both of whose names are entitled as holders of beneficial interest in the records of the depository, unless a proper instrument of transfer in such form as may be prescribed, duly stamped, dated, executed by or on behalf of the transferor and the transferee, and the specifying name, address and occupation. So if you purchase any shares using your Demat account, you may get the invoice copy in which you can see the number of shares which are purchased for you and your name as the beneficial owner. It will be dated and executed on behalf of the transferor, as Demat account appoints the depository handler as power of attorney, and the transferee and the specifying name, address and occupation, if any of the transferee has been delivered to the company by the transferor or the transferee within a period of 60 days from the date of execution, along with the certificate relating to the securities, or if no such certificate is in existence, along with the letter of allotment of securities, provided that where the instrument of transfer has been lost or the instrument of transfer has not been delivered within the prescribed period, the company may register the transfer on such terms as to indemnity as the board may think fit. Nothing in subsection shall prejudice the power of the company to register on receipt of an intimation of transmission of any right to securities by operation of law from any person to whom such right has been transmitted. When an application is made by the transferor alone and relates to partly paid shares, a transfer shall not be registered unless the company gives the notice of the application in such manner as may be prescribed to the transferee, and the transferee gives no objection to the transfer within 2 weeks from the receipt of notice. Every company shall, unless prohibited by any provision of law or any order of court, tribunal or any other authority, deliver the certificates of all securities allotted, transferred and transmitted within a period of 2 months from the date of incorporation in case of the subscribers to the memorandum, within a period of 2 months from the date of allotment in the case of any allotment of its shares. So you should note the difference between subscribers to the memorandum and allotment of any shares, allotment holders. Within a period of 1 month from the date of receipt by the company of the instrument of transfer under subsection, or as the case may be of the intimation of transmission under subsection 2 in the case of a transfer or transmission of securities. Within a period of 6 months from the date of allotment in the case of any allotment of debenture, provided that where the securities are dealt within a depository, the company shall intimate the details of allotment of securities to depositories immediately on allotment of such securities. The transfer of any security or other interest of a deceased person in a company made by his legal representative, even if the legal representative is not a holder thereof, be valid as if he has been the holder at the time of the execution of the instrument of transfer. Where any default is made in complying with the provisions of subsections 1 to 5, a company shall be punishable with fine which shall not be less than 25,000 rupees, but which may extend to 5 lakh rupees, and every officer of the company who is in default shall be punishable with fine which shall not be less than 10,000 rupees, but which may extend to 1 lakh rupees. Without prejudice to any liability under the Depositories Act 1996, where any depository participant with an intention to defraud a person has transferred shares, it shall be liable under section 447. Punishment for personation of shareholder. If a person deceitfully personates as the owner of any security or interest in a company, or of any share warrant or coupon issued in pursuance of this act, and thereby obtains or attempts to obtain any such security or interest, or any such share warrant or coupon, or receives or attempts to receive any money due to such owner, he shall be punishable with the imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. Refusal of registration and appeal against refusal. If a private company limited by shares refuses, whether in pursuance of any power of the company under its articles or otherwise, to register the transfer of or the transmission by operation of law of the right to any securities or interest of a member in the company, it shall, within a period of 30 days from the date on which the instrument of transfer, the intimation of such transmission, as the case may be, was delivered to the company, send notice of the refusal to the transferor and the transferee, or the person giving intimation of such transmission. So the private companies can refuse to the transferor and the transferee, or the person giving intimation to such transmission, as the case may be, giving reasons, by giving valid reasons for such refusal. Without prejudice to subsection, the securities or interest of any member in a public company shall be freely transferable. In private company, it's not freely transferable, but in public company, it is freely transferable, provided that any contract or arrangement between 2 or more persons in respect of transfer of securities shall be enforceable as a contract. A transferee may appeal to the tribunal against the refusal within a period of 30 days from the date of receipt of the notice, or in case no notice has been sent to the company, within a period of 60 days from. So, with a notice, within a period of 30 days, without a notice, within a period of 60 days from the date on which the instrument of transfer or the intimation of transfer, as the case may be, was delivered to the company. If a public company without sufficient causes refuse to register transfer of securities within a period of 30 days from the date on which the instrument of transfer or the intimation of transmission, as the case may be, is delivered to the company, the transferee may, within a period of 60 days of such refusal, or where no intimation has been received from the company, within 90 days of the delivery of the instrument of transfer or intimation of transmission, appeal to the tribunal. A tribunal, while dealing with an appeal made under subsection 3 or subsection 4, may, after hearing the parties, either dismiss the appeal or by order direct the transferor or transmission shall be registered by the company, and the company shall comply with such order within a period of 10 days of the receipt of the order. Different rectification of the register, and also direct the company to pay damages, if any, sustained by any party aggrieved. If a person contravenes the order of the tribunal under this section, he shall be punishable with imprisonment for a term not less than 1 year, but which may extend to 3 years, and with fine which shall not be less than 1 lakh rupees, which may extend to 5 lakh rupees. According to section 59, rectification of register of members. If the member of any person is without sufficient cause entered in the register of members of a company, or after having been entered in the register is without sufficient cause omitted therefrom, or if a default is made or unnecessary delay takes place in entering in the register, the fact of any person having become or ceased to be a member, a person aggrieved, or any member of the company or the company may appeal in such form as may be prescribed to the tribunal or to a competent court outside India, specified by the central government by notification, in respect of foreign members or debenture holders residing outside India for rectification of the registrar. A tribunal may, after hearing the parties to the appeal under subsection, by order either dismiss the appeal or direct the transfer or transmission shall be registered by the company within a period of 10 days of the receipt of the order, or direct rectification of the records of the depository and the register. In the later case, direct the company to pay damages, if any, sustained by the party aggrieved. The provisions of this section shall not restrict the right of a holder of securities to transfer such securities, and any person acquiring such securities shall be entitled to voting rights unless the voting rights have been suspended by an order of the tribunal. Where the transfer of securities is in contravention of any of the provisions of the Securities Contract Regulation Act and the SEBI Act 1992, or this act or any other law for the time being in force, the tribunal may, on an application made by the depository, the tribunal may, on an application made by the depository company, depository participant, the holder of the securities, or SEBI, direct any company or a depository to set right the contravention and rectify its register or records concerned. If any default is made in complying with the order of the tribunal under this section, the company shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees, and every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 1 lakh rupees, but which may extend to 3 lakh rupees, or with both. Publication of authorized, subscribed and paid up capital. The authorized capital, subscribed capital and paid up capital should be published properly. Where any notice, advertisement or other official publication or any business letter, bill head or letter paper of a company contains a statement of the amount of the authorized capital of the company, such notice, advertisement or other official publication or such letter, bill head or letter paper shall also contain a statement in an equally prominent position and in equally conspicuous characters of the company of the capital which has been subscribed and the amount paid up. If any default is made in complying with the requirements of subsection, the company shall be liable to pay a penalty of 10,000 rupees, and every officer of the company who is in default shall be liable to pay a penalty of 5,000 rupees for such default. Let's study the other provisions in the next video. Thank you.